Hello, dear students. So I'm back again with the third lecture of mine on penology. I'm Dr. Vibha Sharma, Associate Professor, Government Law College, Ajmer. I will be discussing the origin and evolution of punishment in this video. So let's start looking at the origin and evolution of punishment. We know that punishment is a designed social reaction to crime. It is a human act and involves deliberate infliction of suffering on the wrongdoer. So we can say that it is an institutionalized suffering. Now, looking at the origin of the term punishment, we can see that etymologically it derives its origin from the Greek term pou, which actually means to cleanse. In the same way, the Sanskrit term dam means to check or to restrain, and the term danda means a stick, staff, or rod. Now, after looking at the origin of the term punishment, let's move on to see the elements of punishment. So, for the sake of revision, we will go through the elements of punishment quickly. Now, H.L.A. Hart with Mr. Bean and Professor Flew published an essay on principle of punishment in Crime and Justice, Volume 2, and he said that there are 5 basic elements of punishment. First is, it must involve pain or other consequences normally considered unpleasant. Then, it must be for an offense against legal rules. Thereafter, it must be an actual or supposed offender for his offense. And then it must be intentionally administered by other human beings other than the offender. And lastly, that it must be imposed and administered by an authority constituted by a legal system against which the offense is committed. So you can see very well that here H.L.A. Hart actually presupposes a well-organized society, and then he comes up with these 5 elements. Now, Greenhut, in his comparative study on penal reforms, came up with the 3 components of punishment. Though it may sound ideal, but still it is worthwhile to go through them. He says that the first is speedy and inescapable detection and prosecution must convince the offender that crime does not pay. Secondly, after punishment, the offender must have a fair chance of a fresh start. And then, lastly, he says the state which claims the right of punishment must uphold superior values which the offender can reasonably be expected to acknowledge. Okay. Now, when we see the elements of punishment as given by Professor Jerome Hall in General Principles of Criminal Law, which was published in 1960, we see that actually he has very systematically brought out these elements of punishment. So he starts saying that punishment is a privation, it is coercive, it is inflicted in the name of state, that is to say, it is authorized. Then, punishment presupposes rules, their violation, and a more or less formal determination of that expressed in a judgment. And then he brings certain ethical values also as an element to punishment when he says that it is inflicted upon an offender who has committed a harm, and this presupposes a set of values by reference to which both the harm and the punishment are ethically significant. And lastly, he also brings out the individualistic aspect of punishment, and that is the extent or type of punishment is in some defended way related to the commission of the harm and aggravated or mitigated by reference to the personality of the offender, his motives and temptation. Okay, so with this we actually can very well figure out the elements of punishment. Now, coming to the evolution of punishment. We all know that all through the ages, the society always reacted to the crimes, and the reactions have been different at different stages of human civilization and differed among various societies. All such reactions fructified in the form of punishment, which was inflicted on the wrongdoer. And so, we will see the evolution of punishment in these different stages, that is early stages, then medieval period, and thereafter modern or new penology. So starting with the early stages, in primitive societies, men shared with animals the emotion of resentment at injury. The sense of fear and ignorance led to barbarous method of treatment of offenders. The concept of law and order was not yet known. So consequently, the common methods of settling disputes were through personal vengeance, such as dual blood feuds and reparation. As pointed out by one of the jurists, in those days, punishment was reflective reaction to injury. So thus we can say that in the early societies, the basis of punishment was retribution and vengeance. Now this obviously led to exploitation of the weaker by the stronger, which resulted in complete chaos. The life and property were most insecure and always exposed to dangers. At times, even the family members of victim or his clan settled disputes with the offender or his family. The cases of property damages were generally settled by compelling the offender to pay compensation to the injured. This remedy, however, was rarely used for personal injuries. But with the advancement of civilization, the sense or respect for mutual rights and duties developed among people, which eventually led to the evolution of law. Later, the state came into existence and took to itself the task of maintaining law and order in the community by punishing the lawbreakers. So the state also sought to redress the grievances of victims who were injured by the wrongful acts of criminals. Thus, the sovereign used punishment as a substitute for personal vengeance through retribution. In early days, the popular modes of punishment were exile, banishment, and outlawry. Now moving on to the medieval period. Now coming to the medieval period, the history of human civilization witnessed an era of religious predominance. The tenets of religion had great influence on the administration of justice and penal policy. Crime began to be identified with sin and violence was abhorred. Ecclesiastical punishments were mixed up with the religious notions of cleansing of the soul for the reformation of criminal. And therefore we find that the ordeal by fire, water, etc. were commonly used to establish the guilt or innocence of the accused. Thus we can say that the genesis of punishment then lay in supernatural forces. And it was generally believed that an offender, by his criminal behavior, actually invoked the wrath of God, which entailed him punishment. Offender's guilt could be washed off by penance, remorse, or expiation, which by itself was a sufficient punishment to mitigate his wrong. Now, this finally led to the evolution of solitary confinement as means of penance by putting the wrongdoer in isolation. Now, it was also believed that if the offender sincerely repents for his offense, the mental torture that he suffers due to remonstrance was in itself a great punishment for him. Though this theory of expiation was criticized by many criminologists, including Garofalo, Sir Leo Page, and Enrico Ferri, and it was found that this theory of expiation actually presented practical difficulties in the determination of exact quantum of punishment which would be adequate to wash off the moral guilt of the offenders. Besides, it also meant assigning the judge a task which cannot be accomplished by human agency. However, because of the belief that the communities as a whole actually held, when we look at the conditions of prisons, we find that they were awfully bad and prisoners were virtually living a life of hell on earth. Deterrence was the cardinal rule of justice, which meant considerable torture and harassment to offenders. So actually punishment here was used as a means to inflict pain on the offenders. The agencies implementing these punishments actually adopted a very stiff attitude towards the offenders. However, with the advancement in science and the social related subjects, there were certain changes also that came in the course of time. So moving on to that aspect. So with the advance of science and knowledge in social disciplines, there was a wave of Renaissance and Reformation throughout the continents. The Declaration of Rights of Man in France in 1787 actually marked the end of draconian punishments and the beginning of methodical system of punishment, which was founded on the sound principle that right to punish is limited by the law of necessity. Now, this obviously brought radical changes in the administration of criminal justice, and in result, penology began to develop as an independent branch of criminal science with the new treatment methods of punishment for the reformation of inmates. A scientific approach actually to crime and criminals had shown beyond doubt that tortious punishment tends to turn offenders more dangerous and aggressive towards society. And alternatively, their rehabilitation through the method of reformation is considered more useful. Now, with this end in view, the modern judicial trend also had to incorporate correctional methods in the penal program so as to bring about rehabilitation and re-socialization of inmates in the community. So now coming to this last part, and that is the modern or new penology. So with new criminological developments, particularly in the field of penology, it is generally accepted now that punishment must be in proportion to the gravity of the offense. It has also been suggested that reformation of criminal rather than his expulsion from society is more purposeful for his rehabilitation. With this aim in view, the modern penologists have focused their attention on individualization of offender through treatment methods. Today, the old barbarous methods of punishment such as mutilation, branding, hanging, burning, stoning, flogging, amputation, starving the criminal to death, or subjecting him to pillory, etc., have been completely abandoned. Now, the modern penologists have substituted new forms of penal sanctions for the old methods of sentencing. Now, the present modes of punishment commonly include imposition of monetary fines, segregation of the offender temporarily or permanently through imprisonment or externment or compensation by way of damages from the wrongdoer in case of civil injury. So now we know that the main object of punishment actually is prevention of crime and the protection of society. And therefore, we also know that no single theory of punishment, which will be the next topic of mine in the next video, will serve the real purpose. Undoubtedly, the credit goes to the eminent criminologists like Beccaria, Garofalo, Enrico Ferri, Tarde, Bentham, and the Indian perspective was highlighted by Dr. P.K. San, actually goes to them, who formulated sound principles of penology and made all out efforts to ensure rehabilitation of the offender so as to make him a useful member of society once again. So I really hope that this video of mine was useful for all of you to understand the origin and evolution of punishment. I hope all of you are studying and are benefiting by our videos. All the very best to all of you for your examinations. Please take very good care of yourselves. All the best. Thank you.